Aji over here. 6 নম্বর 5 নম্বর সুমন সেন্টার 5 নম্বর এটা একদম মানে Hello, tournaments, are you audible? Hello. It is sound to go to opposite. Hello. Hi. Hello, Kohima Men's.
Hello, Principal Seat, are we audible?
Are we audible?
Yes, audible.
Okay, thank you.
Yeah, welcome.
From an analysis of the evidence on record in its entirety and the law laid down by the Honorable Supreme Court as referred to here in the above, we are of the view that the prosecution has failed to establish the guilt of the accused appellant beyond shadow of doubt. As such, giving the benefit of doubt, the conviction of the appellant Sri Mukul Deka is hereby set aside and quashed. Consequently, judgment and order dated 7/6/2017 passed by the session judge still set aside and quashed. The appellant Sri Mukul Deka is hereby acquitted from the charges brought against him, and accordingly, we direct the appellant Sri Mukul Deka be released from jail forthwith. In the result, the criminal appeal stands allowed.
Release order shall be taken now.
Get it printed.
My lord, release order shall get on today, my lord.
Yes.
My lord, release order shall get on today, my lord, from my lord. Gauhati bench, my lord.
You find it out.
Yes, my lord.
The procedure
Yes, my lord.
consequential.
Publish, Your Lordship.
Yes.
I pick the mention duties, mention item number 7, Your Lordship,
7.
in the supplementary list, Your Lordship.
Okay. You want to withdraw?
Yes, Lordship.
Why?
I have taken the instruction from the petitioners, Your Lordship.
Okay. Mr. Subangwati Walik, learned counsel to the petitioner, raised that he may be allowed to withdraw this writ petition. Liberty. Any liberty?
Yes, Lordship.
With a liberty to file fresh list of praise is allowed. The writ petition is disposed of on withdrawal. The disposed of on withdrawal with a liberty as prayed for. Mr.
Publish, Lordship.
May I please, my lord?
Yes,
Lordship, I beg to mention item number 3.
yes,
Here, Lordship, I'm appearing for respondent number 1, and my colleague V. Shokre, additional AG, is appearing for respondent number 2 to 5.
yes.
Lordship, some time may be granted to us to receive necessary instruction, Your Lordship.
Mr. Jimobi,
Nangami.
sorry, Enangami. Learned State Council. Praise that phrase for 3 weeks.
Lordship.
Phrase for 3 weeks time to obtain instruction. Mr. Prayer not being opposed by the learned counsel to the petition. Mr. Swainson, learned counsel. Not being opposed by Mr. Swainson, learned counsel to the petitioner. Mr. Prayer is allowed. Not please stop, comma. Prayer is allowed. List its matter after 3 weeks.
Lordship. Deeply obliged, my lord. May I please, your lordship. Lordship, I beg to mention item number 2, your lordship.
2.
Yes, lordship. On behalf of the counsel for the petitioner, Mr. Tiko, your lordship. Lordship, today he has some personal difficulties, your lordship.
Yes.
So I pray that this matter may come up on 21 of August.
Mr. So-and-so, learned counsel for the learned counsel appearing on behalf of Mr. Digo, learned counsel for petition. Present granted 3 weeks time.
Lordship, a date may be fixed, your lordship, since he's
This matter on 21/8/2023.
the interim may be continued, lordship. Obliged, my lord.
Lordship, item number 5.
5.
Lordship, I am for the respondent number 2.
Yes.
I filed my Wakalatmana and also my affidavit in reply this morning.
Am I so-and-so, learned counsel appears on behalf of
Respondent number 2.
respondent number 2.
Yes.
She submits that she has also filed a counter affidavit.
Yes, lordship.
Mr. So-and-so appears for the petitioner. Then list of BG Momi,
Yes, on behalf of Mr. V. Jimomi, lordship.
BG Momi.
On this, yes, lordship, on behalf of Mr. V. Jimomi.
You are appearing on behalf of BG Momi.
Lordship.
You just write BG Momi for
Yes.
state PP.
Lordship.
List this matter after.
Lordship, I pray that this matter also come up on date 21, lordship, since the counsel for the petitioner is the same.
List this matter on 21/8.
Yes, lordship.
22.
Lordship, there's an interim here also, so I pray that this may continue.
Interim order. Also, let's continue.
Obliged, my lord.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 1. Our affidavit in reply is ready, but we are waiting for the client's signature. So kindly grant us 1 week time.
What is there? Where is Joshua?
Uh,
What affidavit in reply?
Affidavit in reply.
Respondent. Who is
On behalf of Aile Matoshi, who is the counsel for the private respondent, lordship.
Huh?
Respondent number 1 and 2. Aile Matoshi.
What is the objection? It's a revision petition. In a revision petition, how you can take a preliminary issue, I mean, objection. That could be the part of your main pleading or the objection in the main pleading. So far as that case is concerned. But filing a revision petition, there cannot be any delay or barred by the section 64 of Limitation Act. Who is appearing? Your senior?
No, lordship, I'm appearing on behalf of Aile Matoshi, lordship, who is counsel from Dimapur, lordship. So since they are going to seek time in adjournment, so he cannot come up today, lordship. That's why I'm appearing on behalf.
I thought I'll dismiss the preliminary objection today. See, you may have a point in raising the issue in so far as the merit is concerned. But for filing a revision petition, section 64 will not be attracted. This may be on the merit. So far as your the plaint or the suit before the appropriate court. This may be a valid ground, but not the filing of revision petition. Is not it? There is questioning the maintainability of the revision petition.
Yes, Your Worship.
This cannot be. You may question the maintainability of the suit. That is to be in the merit, not as a preliminary issue. Anyway,
1 week, Lordship.
I thought I'll dispose of this objection. Anyway, I may so and so learned counsel for the petitioner submits that she may be granted some time to file the affidavit.
Affidavit in reply.
Affidavit in reply to the objection on maintainability raised by the respondent number 1 and 2.
Lordship.
1 and 2.
Yes,
Who has
Lordship.
raised that? 1 and
1
2.
and 2.
Mr. They are not being opposed by the learned counsel for respondent number 1 and 2. Mr. Same is allowed. List this matter after
1 week.
a week.
Much
Right,
obliged.
May I please, Your Lordship?
Item 4.
Sorry.
Item 4.
Yes, Your Lordship.
What? What do you want?
Your Lordship, we have taken steps upon respondent number 2. However, respondent number 2 is yet to,
My lord, in this matter, I have instructions to appear for the respondent number 2.
Okay, in that case, then,
Then I'll be filing my power in the course of the day.
okay. MS so learned counsel for the applicant, public petitioner present. Mr. So and so,
And Mongkumen.
Anguli,
And Mongkumen. And Mongkumen.
learned counsel for the learned counsel submits that he has an instruction to appear on behalf of respondent number 2, for which he will be filing his wakalatnama during the course of the day. Mr. In view of the above, this matter after 4 weeks. 4
Yes,
weeks.
Yes, Your Lordship. Much obliged.
It's not a case of breach of contract. It's a 138 case,
138 Lordship,
NIA.
Lordship 138. But the Lordship problem is that there are 2 accused and the present petition
You have, the check is signed by you.
check has been signed by me, but no relationship could be shown between me and the complainant.
It's okay.
And
But
one
then once you issued,
but under 138
well,
Lordship,
let us see your check.
yes, check Lordship.
Where is the
Lordship will
check?
Find that page number 22.
22.
I am not
Yes.
disputing the check Lordship.
Is it not by you?
It is by me.
Jitumoni
Yes,
Talukdar.
Bitumen Talukdar.
And
But it may be of some other transaction Lordship, because the entire allegation revolves around the accused number 1, not accused number 2. Only thing is that he has
that's why there is a case is established
no
against the person who has issued the check.
no Lordship, but under 130 and NIAC Lordship, there has to be a legally enforceable debt. And from the petition as well as the evidence, no such debt or liability could be shown by the complainant Lordship. I may,
But then that is admittedly issued by the accused number 1.
accused number
I mean, given by the accused number 1,
accused number 2,
accused number 2.
2,
You are the accused number 1.
accused number 2. I am the accused.
Issued by you,
Issued by me,
but they handed over by the accused number 1.
handed over by the accused number 1.
Informant, complainant.
That is the allegation. But the accused number 1 could not have handed over this check to him.
Did you file any case against that this check has been not issued by me? It has been obtained by fraud or whatever.
No Lordship, because I have stated in para Lordship.
You know that the
There are
check
5.
has been handed over to somebody
Yes.
and signed by you. and you are just keeping quiet. What does it indicates?
Yes, Lordship, but we both are the partners
I understand you don't have any relation with the informant,
with the complainant. Yes.
but you have the relation with this Mr. Accused number one.
But that Lordship, the complainant has to
No.
show.
No, that will be a matter of investigation, that will be a matter of evidence. Now, admittedly, we could understand if you had filed some complaint against the issuance of this check.
But
You are just keeping quiet.
my Lordship statement
The
is that
moment you came to know this,
this,
the check has been issued by somebody, I mean, given to somebody,
Lordship.
it is your duty to approach,
Approach the concern.
to take appropriate remedy.
But Lordship,
mean,
because of business relationship, my blank check could have been
That I have seen.
Yes, yes.
But then factually, there's something wrong. See, I'm just repeating again.
Lordship.
You came to know the check which belongs to have been handed over to somebody by somebody,
Yes, Lordship.
someone else. Is it not your duty to take recourse to appropriate remedy?
Lordship. That
You cannot just keep quiet. There's something more than what you are.
Yes. But Lordship, the other fact also is that the entire allegation revolves around accused number one and the accused complainant.
No, I have seen all this.
Complainants.
That's why I'm saying.
Complainants.
I have seen it.
Yes.
There's no relationship whatsoever with
Yes.
you.
And also
with the
petitioner.
informant and the
Yes.
complainant. But then facts remain that this check has been issued. It's your check.
It's my check.
Handed over to the informant by the accused number one.
That is their.
You may not take any, you cannot take any action against the informant, which you don't have any relationship.
But I admit that I should have
But-
taken some
Against this.
against the
accused
accused number one. But Lordship, in the evidence, there is no whisper about any relation between
But
me
then
and the
facts remain the check handed over. It was, for collection, it was placed before the
bank.
bank. Now let's see
But
what
Lordship,
the provision, but it says
130
NIA.
NIA.
Negotiable Instrument Act.
Lordship.
The accused number one is your friend. Your partner.
Is my friend. Accused number.
He has flagged
partner.
fraud on you. That you are keeping quiet.
That part, Lordship, I admit. 138, Lordship.
138.
Married.
This way. Yes,
Dishonour of check for insufficiency, etc. for funds in the account. Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for a discharge. This is important, for a discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with the bank. Such person shall be deemed to have committed an offence and shall, without prejudice to any other provision of this act, be punished with imprisonment for a term which may be extended to 2 years, or with fine which may extend to twice the amount of the check, or with both. So this is the section, Lordship. The main, Lordship, ingredient is that the complainant has to establish the legally enforceable debt or liability. In this case, there is no legally enforceable debt or liability
But-
shown
accused number one.
against the accused number 2.
Accused, it lies against the accused.
Against
number
the
one.
accused number 1. But against the accused number 1 also, the agreement which is alleged to have entered into by both the accused number 1 and the complainant is not neither annexed nor exhibited.
No, that is not your lookout. That is not your lookout.
That is not my lookout.
Accused number, admittedly, accused number one has issued it, handed over the check. Whatever may be the,
Yes.
whose name may be, whatever
Yes.
may be.
Yes.
But the informant has accepted it and placed it, submitted it
before the
before
bank.
the bank. It has been dishonored.
But on merit lordship, that I want judgment also. Small judgment lordship. On the ingredients of section 138. Page number 6, down below, lordship will find. Para 20. It's 2008 4 SCC 54.
Para 20.
Para 20. Page number 6, down below. Starts with indisputably. Indisputably, a mandatory presumption is required to be raised in terms of section 118B and section 139 of the Act. Section 13(1) of the Act defines negotiable instrument to mean a promissory note, bill of exchange, or check payable either to order or to bearer. Section 130 of the Act has 3 ingredients. Viz. Number 1, that there is a legally enforceable debt, that the check was drawn from the account of bank for discharge in whole or in part of any debt or other liability which presupposes a legally enforceable debt. And that number 3, that the check so issued had been returned due to insufficiency of funds. Lordship, that ingredient number 2 and 3 are lordship affected, but 1, that there is a legally enforceable debt, could not have been shown against this petitioner, accused number 2. It may be against the accused number 1. Entire case revolves around accused number 1. But only thing that accused number 2 has issued that check. But it is not in their pleading that he has issued this check on behalf of the accused number 1. The complaint has not even averred that also. That accused number 2, on behalf of accused number 1, on being authorized, had issued that check. Only thing that he has issued this check. Only that line is there. But whether in a case of NIA lordship, 2 accused can be there for 1 check. And even if I assume that the conviction is done, given. In that case also, whether both these accused person can be convicted under for 1 check. Whatever may happen, it's between complainant and accused number 1 lordship. Accused number 2, there is no legal enforceable debt.
Can we
Lordship,
stay the proceedings?
no, Lordship.
No, just wait. Stay the proceeding in respect of the petitioner. Is it permissible? No.
It can be.
No,
Otherwise,
Lordship.
it will be-
Lordship knows better that.
No, admittedly,
Yes.
he has no debt or whatever, one of the ingredients. He has no relationship with the informant, but he does have a relation with the accused number 1. And admittedly, check has been issued. The petitioner issued a check which was handed over to the informant by according to his lordship. So today, obviously, we'll issue notice. What is the stage?
Stage lordship appearance.
You appear. What's there? You'll not be arrested. You
I
appear.
will not be arrested, but in the
We'll
meantime,
see,
lordship,
we'll call for the
LCR lordship.
LCR.
Lordship.
Will not pass any interim order today because it's an appearance only. You'll not be arrested.
I will not be arrested, but
Then
to go there and take lordship bail.
No, you have done something. You have not done your duty also.
Lordship, that is
When you
that's a
come to
fault.
know that unauthorizedly your check has been given to someone, your partner, if it's misused or something like that, which resulted in such a serious issue,
Serious issue, lordship.
then so in view of that, will not say.
Lordship, in respect,
I understand that cost ingredient doesn't attract to him. But we'll see it's just an appearance.
but lordship may also stay the proceeding in respect of the petitioner also, this petitioner.
No, that
The accused number
it will be a difficult. That's why I'm asking. Let us be fair, very fair. Suppose if in respect of petitioner, if it is stayed, things will not be able to move. Is not it? I mean, truth has to come out.
Truth has to come out.
So you will not be arrested, nothing, there's no question of
It's a
arresting you.
bailable offense. I will be granted.
So there's no issue.
But lordship,
Next date
till-
we'll see.
Till the eternal,
No,
the
no.
state on
No,
next
it's
day
not a
lordship
question-
may
there's not a question of stay. let us be very fair. You are an officer of the court.
Lordship.
Because this is something which I understand. If you find there is nothing against you, prima facie there is nothing except your
Conduct.
take the check in your name.
But I should,
If you can
actually,
say you should have taken some
I
steps,
should have taken some.
then matter would have been different.
Maybe due to some friendship, he might not have.
Tell
approached.
him, take some action so that we can take care
That
of,
may be the
you.
Lordship.
See,
Lordship.
forget the friends.
Lordship.
Once you are in the dock,
Lordship.
you think about yourself. Friends is always friends.
Lordship.
Or if you sacrifice for your friend, this another matter.
Lordship. That's
You are kind enough to sacrifice yourself.
that's
Yeah?
true.
So we will issue notice today. We'll call for the LCR. We
Lordship,
don't pass any.
Lordship, however,
Trip.
in view of the order passing action resurfacing of road agency,
Huh?
in view of the order passing
Huh?
in view of the order passing action resurfacing of road agency by the apex court, Lordship, the LCR in respect of LCR, the last fifth paragraph, Lordship.
We also did it.
Yes.
Yes.
So
That is this thing.
yes.
Scan copy.
Scan copy.
Scan
That is the
copy.
procedure. Scan
Yeah.
copy. Otherwise, the whole proceeding will
You
be.
have to remind, because in other bench, we used to call even the CD.
Lordship.
CD also, case diary also scan copy.
Lordship.
This is the procedure.
Lordship.
I missed it, in fact, in this bench. You could have.
My apology. I used to forget sometimes. Lordship.
Principal seat and internal bench,
My apology, Lordship.
so it has slipped from my mind also.
This is the court. My apology, Lordship.
So you also remind us. This is the procedure you have been following. How could it has slipped from the court's mind? It's your duty also.
Yes,
Could
my
have
duty,
pointed out.
Lordship. I'm responsible.
Anyway, heard Mr.
And Hassan Lordship.
and Hassan, learned counsel to the petitioner, and also heard Mr. Tiangami, learned public prosecutor for the state of Nagaland. The petitioner, by instituting this application under section 482 of CRPC, 1973. The petitioner has prayed for quashing of the complaint case being CR case number 02 of 2023. Pending before the Court of London Judicial Magistrate First Class, Dimapur. And its consequential proceedings under section 138 of Negotiable Instrument Act. Issue notice returnable within 4 weeks. Call for the scan copy of the LCR from GMFC Dimapur. Mr. Hussain, learned counsel for the petitioner, shall take a step for service of notice upon respondent number 2 by registered post with the AD within 2 days. List this matter after 4 weeks. That's all.
Yes, Lordship, if I may be allowed. scan copy slash photocopy, if that can be inserted.
It includes photocopy,
Yes,
then you have scan copy slash
because
photocopy of the LCR.
others can be so,
It can be written too.
Yeah,
Scan
but-
copy includes the photocopy.
they can be so confused sometimes. What to do? with the kind of thing?
You tell them, you don't confuse. You read into the photocopy includes, I mean, scan copy includes the photocopy.
Lordship steps by registered post AD.
Lordship
may kindly fix a date after 4 weeks.
You just give the date.
August, Lordship. September first. September, right?
8 September,
Keep September.
5/1/5/9.
And Lordship, my
That
prayer.
will be 6 weeks.
No, Lordship, today is Lordship.
It's 29 July, 28 July.
After 4 weeks.
Last part.
Last part of August.
Anyway,
28.
5/5/9.
And Lordship, my prayer for interim will be maybe consider on the returnable date.
We'll see. We have not rejected your interim prayer.
Lordship may reflect that, Lordship.
The list is before that, huh? Before listing, the interim prayer of the petitioner shall be considered on the next returnable date.
Lordship.
If LCR comes, we may dispose of it. Isn't it?
Lordship. The prima facie, there is no case against me, Lordship. That first part is missing.
Prima facie, not prima facie, admittedly,
Admittedly.
undisputedly, you have issued the check.
I have not disputed the check.
You have issued the check.
I have,
How it has been handed over, we don't know.
yes, I should have taken reports of that. That is a fault. Obliged, Lordship, deeply obliged. Should have gone to police. How to say that?
From the section, brought 2 over.